Greetings, everyone. Welcome to our exclusive Global Leading Voices webinar campaign. We are delighted to have you join us here today. Please be informed that if you have any questions during the presentation, you may type them into the question box in your control panel. The presenter will answer your questions at the end of the presentation accordingly. Now, without further ado, we will turn the time over to our presenter, who will begin shortly.
Well, hello, everyone. Welcome to today's webinar dealing with ISO 27001, ISO 27701, and data privacy laws and key threats in this year. Today, I'll be co-presenting this presentation with Alfonso. Say hello, Alfonso.
Hey guys, how's everybody doing?
And I'll be doing more on the security side, while Al will be doing more of the privacy side. So a little background about myself. I've been in the field for about 20 years now, cybersecurity field for about 20 years. Did 21 years of consulting. Now I work for a national law firm where I developed their cybersecurity and privacy programs. I'm also the president of the New Jersey IEC Squared chapter, which is no longer just for New Jersey. So if you want to be a member, you're out of the country or out of the out of the state or out of the country, we take all members. I'm also on the executive and threat intelligence committees of the ISAO, which is an information sharing organization for the legal services area. And I also do some volunteer work with mentoring, and that's about it for me. Alfonso?
Sure. So welcome everyone. My name is Alfonso Yi. I just go by Al. I'm currently the VP of Data Privacy and Security for a software services and data analytics organization focused in real estate. Previously, I did work for a Fortune 500 luxury brand and was a CISO for a private consulting firm that specialized in regulatory advisory services. I hold a couple of different accreditations and certifications similar to Ken in privacy and security, and really enjoy, doing different work in this space. It's always fun to do these webinars, and it's just a great educational exchange. So, pleasure to do this one with you, Ken.
Great, thank you. I mean, one of the reasons why I wanted to do this particular presentation with Al is that there's a lot of cybersecurity professionals out there who really don't understand the privacy landscape. And I wanted to show everybody that it's not that complex. It's not only for lawyers, and there needs to be more cybersecurity professionals in this space as well. Al is not a lawyer, and there are so many positions that are going to be opening up in this field that it really, and I also want to show you how even ISO has changed and incorporated privacy into their into their frameworks and standards as well. So we're going to go a quick overview over ISO 27001 and ISO 27701, which is the privacy standard. Then we're going to talk about how they intersect. We'll talk about the privacy landscape and the key threats of 2022. So to start off, ISO stands for the International Organization of Standardization, and it's really a framework of policies and processes that create this thing called an information security management system. Now, the cool thing about this is that it's an approach, it's called an ISMS. And what it is it's a systematic approach to managing information risks where you'd have to take certain measures in order to either mitigate, avoid, accept, or transfer unacceptable risks. And this for those who are familiar with a SOC 2, if you're in the United States, a SOC 2 is a very similar type of audit that is performed, but it's different in a sense because an audit is only reports on evidence to prove a level of security maturity, while an ISO 2701 certification is used to define, implement, operate, control, and improve your overall security. So it's really, you're building a program as opposed to just making sure you have the evidence to pass a certain audit year after year. The idea with ISO is that you're continuously improving. And you can see here this information security management system composes of several different things in order to achieve that objective. You have to get the right stakeholders in place. And that's usually the heads of departments, whether it's the CFO, the COO, head of HR. All those people need to come to the table because they're going to be very important when you're discussing cyber risks. You have to identify those risks, define what measures you're going to do to handle those kind of risks, and how you're going to do it, and then you're going to implement it. And the biggest one for me is the metrics, because if you can't measure it, then you really don't know if your program is successful or not. And lastly, you have to show continuous improvement. And of course, for those who know, for those that don't know, CIA is the triad for information security: confidentiality, integrity, and availability. So it's very flexible. It's not prescriptive. There's a lot of frameworks out there that are much more prescriptive. And what Al's going to show in the next slide is the 27701, which is really just an extension of this model. It's not a whole new system that you're building, but it's just an added layer to it.
Yep.
Take it away.
Thanks. Thank you. So as you saw, Ken outlined the ISO 27701. This is, as he mentioned, an extension to that, same organizations, but here we're basically leveraging this extension to handle personal identifiable information. And we're creating, similar to the security, a privacy information management system. So it's dependent. It's basically using that information, what you've learned during that pre-building in the security aspect, to create these pieces of your program. The important two things to take away here is that it's regulatory agnostic, meaning it's a unified system of operational controls that can be used across your organization regardless of what regulations or laws related to privacy are involved. And compliance can be determined in a single audit cycle as opposed to having to do numerous audits for SOX, for HIPAA, for different regulations across different regions depending on where you have to conduct it. And finally, objectives are similar to accommodate jurisdictional specifics, as I mentioned. So it doesn't matter what kind of regulations or laws are involved, to create transparency between the stakeholders and parties, and finally to facilitate an effective business agreement and contract. So that's something that is critical in any kind of privacy discussion. You're going to have different parties involved, so you want to make sure that everybody agrees what kind of contract language is the basis for doing this. And finally, as Ken mentioned earlier, security is the foundation for everything we do. You can't have privacy without security. This was a message sent by Michael Kirchhoff during an interview with the Huffington Post, and he was the former Department of Homeland Security under President George W. Bush in 2015. So interesting article from him. Ken?
Yeah, thank you, Al. So we have a question here that's really a layup for us. The question is the ISO 2701, will there be a new version of it soon? And the answer is yes. So they just developed the guidelines for the new version, and we're going to go into what has changed, okay, in the draft so far. So we will address those questions. We will address that question, so don't worry about that. So these are the current security controls. Now you got to realize that this was made in 2013. So it took them 9 years now to make changes to this. So, and a lot has changed, obviously. If you want to compare it to another framework such as NIST, NIST is much more technical involved, where ISO is more risk-based. And there's 114 controls with this version of the ISO 2701. These are called Annex A controls. There's clauses, there's management clauses, and then there's these Annex A controls, and it's divided into 14 categories. And there is a hint of privacy within these controls. They did think about it to some extent, but you'll see in the next slide that they're gonna ramp it up much more. So, for example, they had don't use sensitive information in a test environment when you're developing software. Make sure you have a clear desk and a clear screen policy, so that way when you leave your desk, nobody can walk around and look at sensitive information. Very important for any organization to have. And lastly, they talk about how to deal with sensitive information during a breach. So those were the three main privacy areas that they did touch on. Now we take a step forward and look at the draft that's coming out for this year, and things have changed dramatically. So they've added 11 more controls to it. They've rearranged the format of it, which I'm not going to go into detail with this presentation because the main gist of this is not to talk about the differences. But the things that I do want to talk about are, one, threat intelligence. So that is where you're getting, it could be getting technical feeds from different sources so you can understand the latest threats that are coming down the pike. Or it could be something like that organization that I joined. It's an information sharing organization. I don't know if those are familiar with ISAC. That is another one that's very big. But there's information sharing organizations in all different industries. And I highly recommend that you look into getting your company to become part of that, because that was really instrumental to my success at my current law firm, because I was able to share ideas about the latest threats, learn about what law firms are experiencing as far as threats, and that's where you really get the strategy of threat intelligence. Next is they started talking about cloud security. If you really want to learn more, go into depth about cloud security, you can get ISO 27017 certified, or at least use that as a blueprint to make yourself more certified, make yourself more secure in the cloud. Oh, there's another question here. We're going to be discussing that in a minute also. The question is, how does ISO 27701 fit into the requirements for the GDPR? So I'll talk about that in a second. Now, some of the other things that are going on as far as privacy with the new standard is data leak prevention. And that basically means that if someone tries to upload social security numbers or other private information, they would either be blocked or they would only be able to do it using certain secure methods. So that's a very important thing to have. And at a minimum, you could at least log that that's been happening. So if you needed to let that information go through, you could at least have a record of it. But it is one of the biggest problems that we have today, and I'll go into a little bit more detail about that later on, because it's so easy with all these different cloud sharing services to take data from a company and move it into the cloud. Then there's data masking. Data masking is when you're covering up the information, such as like you've all seen where your social security number only shows you the last 4 digits of your, of it. Data masking would cover the entire number so that nobody could see anything, and it would be hidden from the viewers that didn't have access to it, to that sensitive information. And lastly, the other thing that this new standard has as far as privacy is information deletion. With the GDPR, there's a new part, and it's also with other privacy laws as well, where they talk about the right to be deleted from a system. So you have to make sure that you have mechanisms in place to make sure that if somebody wants to be deleted from their your system and they're no longer doing business with you, that you have the capabilities to delete that information and to minimize whatever information you have, because you shouldn't be keeping information that is sensitive that you don't absolutely need. So if you have a client that hasn't done business or a customer that hasn't done business with you in over 10 years, that should be removed, only if there's legal reasons. Is it the same as encryption? Sorry, that came in. I don't know what context that is for the question, so we can talk about that. I think that was
in the context of the hashing or the data masking.
Oh, the data masking? No, it's not. Well, it is a form of encryption, but it's not done the same way. All right, and the last thing that I wanted to bring up was secure coding. If you want to learn more about secure coding, I suggest you take a look at OWASP Top 10, where you can learn about input validation, session management, access controls, encryption. These are all different techniques that one needs to learn if you're a developer on how to do secure coding. So as far as where security and privacy hit, this is one of the biggest areas, is when a breach happens. I'm showing you here an example of what happens if your system got compromised by a ransomware attack. This is what you might see. This is an actual message that somebody received where it gives you this nice little friendly message saying that you've been hacked, this is what you need to do, and this is how you need to pay us. And obviously everybody's heard in the news about how ransomware is prolific everywhere around the world, and it's only going to get worse. But the latest techniques that they're using is something called double extortion, where not only will they be encrypting your data so you can't use it anymore, but they will also be making it public. And that's something that no technology, once it's out there, there's no technology that can stop that from happening once it's out in the public. So it's very nerve-wracking for a company to have this happen to. And me being in the law firm industry, we have a lot of client-sensitive information. So it's something that we've brought up over and over again when we do tabletop exercises. And a tabletop exercise is basically a fire drill. So we do a mock ransomware attack at our firm, and we have all the key people involved: head of HR, head of finance, our marketing department, PR, IT, of course, and legal, naturally, and we all get together and discuss scenarios of what would happen if we did have a breach, and how that would affect the sensitive information, the PII, or the PHI for that matter, the personal health information as well, protected health information as well. And once you're dealing with privacy issues, when you have a breach, you have to start thinking about credit monitoring services, dealing with regulatory agencies, and possibly giving your customers or clients breach notifications that this happened. Now, one thing that I do recommend you do from a technical aspect is obviously backups are extremely important, but there's a big push for people to start having something called immutable backups, which are called worm backups, write once, read many. And that way, no matter how, like a lot of times these hackers are now going after your backups. So you want to have something like this in place so that no matter what, those hackers can't touch those backups. Very important. Again, your backups are less important if your data is out in the public. So you have to start thinking about having a crisis management team to handle that. Next, I wanted to go over some of the common privacy principles that most of the privacy frameworks all over the world use. And Al's going to go into some detail about that. But the first one is notice what data is used The notice basically means you want to know what data is used, how it is used, and the purpose for collecting. All this should be transparent to the consumer at all times. You also want to think about choice and consent. The right to opt in, that's a key tenet of the GDPR, whereas opposed to the CCPA, which is the California Privacy Act, opt-out is used. They don't have, you don't need to opt in if you want to receive marketing information. You just have to opt out, which is easier for the marketers, obviously. Data should be not given to third parties without a consumer's consent. The next topic is access and participation. Access rights and control of data from owners. It's that's very important. The people want to be able to edit that data. They want to be able to delete that data, and it gives them a more sense of ownership. Relevancy. You want to make sure that the data that you've collected is used for its original purpose and is obtained lawfully. So let's say you have some data that you're collecting for a particular marketing campaign. You can't start using that data for a different marketing campaign. Then there's enforcement, where you have owners or custodians of data, people who are managing that data. They should be held accountable. And lastly, you'll see security and accuracy. Accuracy is another word for integrity, really, for the most part. It's just privacy gives it a different kind of, a slight different slant. And you have to make sure that those safeguards are in place. So there was a question before about whether, how does ISO tie into the GDPR, and it ties in beautifully. So if you follow the ISO 2701 security standards, you will meet all the security aspects of the GDPR. And that's the same kind of idea that the privacy framework is, the 27701. If you follow that framework, you will at least have the overall privacy program set up. You will not be completely covered for GDPR because there are very specific nuances within the GDPR, even within the individual countries. And Al's going to talk about that a little bit, but it's really, this gives you the framework, though, so that you can deal with that at a high level, and then you can go down to a more regional level. All right, Al.
Thank you, Ken. Great background. And I just wanted to talk a little bit about, what is privacy? And the reason for it is a lot of terms have been used today, and I want to make sure that we have a good foundation on which all these definitions are based. So with that, I want to talk a little bit about 1948 United Nations Universal Declaration of Human Rights, Article 12. No one shall be subjected to arbitrary interference with their privacy, family, home, or correspondence, nor to attacks upon his honor or reputation. Everyone has a right to the protection of law against such interference or attacks. This is the basis for all international laws and regulations related to privacy. Everybody, leverages this, and we'll go into how this has been defined by the Organization for Economic Cooperation and Development. And then finally, on this point, there has to be a balance of this fundamental human right with the legitimate interests of various organizations and third parties, such as governments, commercial interests, and individuals. And the way that you do that is conducting something called a legitimate interest assessment. And we'll go into that in a little bit more detail later, but for right now, for the GDPR, it's, remember, legitimate interests include consent for the fulfillment of a contract, other legal obligations, protection of vital interests, which is in case of life and death, completion of public tasks in terms of government interest, legitimate interests necessary for controllers and third parties. What do these tests really mean? It's what purpose is the data being used for? What are you processing the data? Whose benefit is it for? Things such as necessity, is the data processing necessary for the primary purpose? And then balancing, who is this benefiting? Is it benefiting more the individual performing or capturing the data, or the individual whose data it belongs to? So something that needs to be defined when you're doing a legitimate interest assessment. Here, what Ken's bringing up is our definitions, right? If we don't know what personal data means and what data processing means, it's kind of useless, any organizational or technical controls that we apply. You'll see that in the European GDPR, US CPRA, the definition of personally identifiable information, or sometimes referred to as data, varies slightly, but overall it means any information that can identify a living person. As far as the GDPR, they're known as data subjects, and it's typically name, government ID, an email address, date of birth, any of this, behavior or biometrics. So something people don't think about is facial, voice, hand geometry recognition, or a heartbeat. That could be used to identify you, something to just be aware of. And data processing, just anything that can be done to data. And in terms of, again, the GDPR, it's not just electronic manipulation of data, but anything down to a file cabinet, any kind of data organization or management. Move on, Ken. All right, and then Ken mentioned a few times sensitive data. Sensitive data is nothing more than a subsection of personal data. In the case of the US, here's a couple of areas that are considered sensitive data according to HIPAA, CPRA, COPA, Fair Credit Reporting Act. In Europe, slight differences in that definition. Next, Ken. Yep. So it's ethnic, racial data, political opinions, religious or philosophical belief, trade union membership, genetic or biometrics, relevancy to sexual life and orientation. And in China, it's more about person's reputation. So financial accounts, credit information. You see that sensitive data, it has different connotations depending on what regulations we're talking about. And one of the key aspects of the ISO 27701 is that once you've defined what those are, you apply the appropriate controls, and you're able to prove and demonstrate conformance with these regulations, regardless of which they are. Next, Ken. So just an example here again, a little bit more of a breakdown between the GDPR on the left and the CPRA on the right. You'll see that there's overlap, but there's certain areas here that just don't directly correspond one-to-one. Keep going, okay? This is key here. This is what I mentioned earlier. The Organization for Economic Cooperation and Development is an international government organization consisting of 38 members that was founded also in 1948, partners with different governments and parliaments, non-government agencies and academia, with the goal to shape policies and foster prosperity and opportunity and well-being for all. They publish about 500 annual reports to talk about different surveys and policy briefs, taking over 5 billion data points. They basically came up with this as a collective to say, what are the key areas to define privacy? So they talk about openness, accountability, collection limitation, use limitation, purpose specification, security safeguards, data quality, and individual participation. And one way to think about this, here's just a sentence that I came up with, is data privacy by design, right? That's the PPD, requires accountability in establishing policies and practices that limit the collection and processing of personal data to a lawful, fair, and transparent manner only for the purpose specified and retention period, during which its confidentiality, integrity, and accuracy must be protected, and individuals given the opportunity to view, correct, delete, or withdraw consent to its processing. There's a couple of asterisks there because within the confines of how that data was collected, the individual may or may not have the ability to delete or withdraw consent if consent was not the lawful or legitimate manner in which it was collected. So just something to be aware of. This is really the foundation, again, on which they take that data privacy premise and apply it to various laws. So you'll see the CPRA, you'll see the GDPR, you'll see different Asian laws really based on these fundamental premises. Next, Ken. And here's just a sampling of some laws around the world. Obviously, there are many, many more. There's over 130 laws. I think there's 198 countries. So the vast majority of countries have either some existing privacy law in place, or their adoption, or they're working on new privacy laws. So it's important, and this is the reason we're here to talk about, how do you make sure that you are in conformance with these laws and you don't run afoul of them. Next. We're talking about Asia Pacific. they take a jurisdictional approach to the OECD principles. So each country essentially has their own interpretation and views of these laws. So just something to be aware of. If you have to deal with Asia Pacific specifically, you're going to be dealing with a country by country basis. It's painful. It's you know, you really have to get into the weeds of these laws and understand, you know, what are the various control aspects, what are the data points that have to be taken into account, what personal data, what sensitive data is there, what type of notices, how you need to notify, or when you need to notify a consumer that their data is being used and for what purposes. Next. Versus in Europe, we have the regional approach, right? The General Data Protection Regulation. It applies to all goods and services regardless of where your company is located. If you're targeting EU residents, regardless of where they're physically domiciled, you have to take care of or keep this this regulation in mind. And here again, the legal basis to process that data, you have to be aware, are you using one of these? If so, you have to articulate it, make sure that you're in conformance with it, and that you take appropriate controls around it. Next, Ken. And in North America, again, more of a sectoral or a state-by-state approach. So each state, you have Colorado, Virginia, California, in addition to some federal legislation that's in place. And then in Canada, you've got the PIDA, the Canadian Personal Information Protection Electronic Document Act. Key here is you can take a, one or two of these regulations and laws and set what you'd call a high water line. Ensure that your program meets those, the requirements for those, and then you can just tweak it to make sure that you have the appropriate level of reporting and get that covered. Again, the ISO 27701 helps you do that. One key call out here is that European data to North America. So if you had personal data of individuals in North America and you were a multinational company and had a legitimate reason for transferring that to North America, you used to have Safe Harbor and Privacy Shield. Those were two legal mechanisms to transfer that data to the United States. Those have both been invalidated. So if you do have that need to transfer the data, the importance again of really understanding what laws you have to operate under, what regulations you're operating under, you need to put in appropriate legal mechanisms in your contracts with the transference of that data, even if it's within the same company. And you have to demonstrate your ability to protect that data once it's no longer in Europe. So just something to be aware of, that both Safe Harbor and Privacy Shield were validated. They're working to come up with a new model, but for right now, you just have to be aware that you have to find another mechanism to do that. Next, Ken.
Yeah, I just wanted to stop here for 1 second also, that you might see within the next coming weeks, it could be that quickly that a new Privacy Shield, whatever they call it, 2.0 or some other sexy name, it's coming soon, hopefully, because the countries, Europe and the U.S., it's really becoming a struggle, the fact that they can't share data easily. And it'll be very interesting to see the next coming weeks, though. I think something's going to happen. Al, did you hear anything to differ with that?
They've been saying that for a while now, since Privacy Shield was invalidated. I know they've been working on something, but I've not seen any drafts published for consideration. So that's kind of what we're waiting for. One good authoritative source for keeping up to date with that, obviously besides yourself and your law firm, Kent, is IAPP.org. They're the International Association for Privacy Professionals. So if you have a need to understand what the latest regulations and laws are related to privacy, they're a good independent source as well. There was a question, Ken, about data processing. How about if you only store or process partial information, such as a few digits or a whole ID number? I guess that refers to a whole government ID number.
Right. You want to take that one? Yeah.
Yeah, I was just going to say that it's a good question, but at the end of the day, if you have enough information that you can identify a specific individual, again, if I say the CEO of a particular company, even if I've not used his or her name or government issued ID or email address, there's enough information there to identify that individual, that's considered personally identifiable. So only storing a few digits of an individual in it by itself does not constitute personally identifiable information. However, if that information combined with other information that you have in your control is available, that's considered pseudonymized information. So it's like taking your locker number, you know, the locker number and the code, ripping the paper in two and putting each piece in a different side of your pockets. If you can combine that information and still identify the individual, that's still considered personally identifiable information. If you're only keeping a piece of information and you have no way to reconstruct the original, that is not considered personally identifiable information. Again, I just want to reiterate, I'm not a lawyer, but I have stood up a few of these programs, and this is passed muster for both our supervisory authorities in Europe and here, our regulators in North America.
Okay. Thank you, Al. We have another question also. For the companies who are on different geolocations representing different countries, how can they unify privacy compliance across borders, and how can they enforce privacy regulations?
Got it. Well, I don't know if a company would want to enforce privacy regulations. The supervisory authorities would do that. But certainly what you would want to do as a company, and in my last company, I had 100 jurisdictions that I had to align with, which is a little challenging. But what we did was that we would come up with a regional model. So by regional model, we said, okay, what does the marketing team want to do as far as retention of data for customers in Europe? The same thing in North America and in Asia. And the answers were, let's say, slightly different, or they had a different business purpose or legitimate interest in how long they kept that data. And you would set the bar slightly different at a regional level. That's perfectly acceptable because you're meeting the needs of the regulations or the laws in that region. So you can have a slightly varying model to your overall privacy program. It doesn't all have to be exactly the same, as long as you're able to comply with the laws and the regulations in the jurisdictions in which you're operating. So it's essentially setting that water line to that target that you want. The reason I say regional is enough, if you tried to go down to the jurisdictional level, you would absolutely go, bananas trying to remember all the different regional, all the different jurisdictional requirements as far as data retention as an example.
Excellent. All right, next we're going to talk about some of the emerging cybersecurity and privacy threats. Firstly, everybody knows about what happened with Colonial Pipeline. So since that proved to be very effective, I am sure we will see an increase in frequency regarding that. Next, I think you're going to see a lot more cloud-based malware attacks. And that's where you're going what I was alluding to before in the beginning, where you're going to see more attacks coming where you'll get emails from Dropbox, Google, or Box, and you think it's from your company because your company uses one of those three, and you click on it, and then you get malware installed on your environment. Now, a way to prevent things like that, those types of attacks, would be something called the Cloud Access Security Broker, otherwise known as a CISSP, where it could block you from using those types of services that are not within the company. So if like the company doesn't use Google Drive, they could make it so that you can't upload to a Google Drive account because that's one of the blocked cloud services. So they're very effective, and you can even do it at the tenant level where you can use your Google Drive, the corporate Google Drive, but you can't use personal Google Drives. So it's pretty granular, and I really like that technology because it really buys into the whole zero trust model, which for many of you have heard of. That's the big buzzword of today, making sure that everybody has the minimal risk, the minimum amount of access over the internet.
Yep. Ken, we have another question that came in. As a DPO, how involved should you get in terms of documenting and vetting/auditing the IT operations of the company and recommending improvements or switch in direction? in your experience, do you find IT managers, personnel is defensive and non-cooperative? It's okay, I'll take that one. Yes, I was the CEO for my former organization, and you have to basically set the tone at the top, right? So you're saying these are the minimum requirements to comply with different regulations. Again, you could do it at a regional level if you have multiple regions in your jurisdiction. But at the end of the day, you want to set the guidelines. You want to establish what those retention periods are. You want to establish data privacy and security by design and default. And we'll talk about that in a little bit. But you set what it looks like when you go and implement, so that by the time you're doing an assessment, the assessment should be nothing more than validating what's already there. If there's deviations from that, then you just bring that group or those parties back to the organization and you try to realign to make sure that they're in conformance with what was already agreed. Super important for this is executive sponsorship and awareness. And if those aren't there in your organization, we need to reassess and make sure that those pieces are built in.
All right. Another question. I'm not sure if this deals with privacy, but I think so. Don't you think this will be hard to manage and track because of the non-uniformity of the policies? So I think they're talking about how, like how you have to have a top level approach and then you work down at the regional and local levels in order to make sure that everybody is in compliance. Would you agree with that, Al, or do you have something else?
No, I agree that first of all, policies should be written at a high level, right? So when we're talking about the policies, those are, what does the organization agree to implement? What in principle are those things that are going to be done? Your procedures and the underlying controls that actually execute against that, you are going to adjust to make sure that you support the business function, that you're aligned with your business goals. And if that's there, you'll get buy-in from the organization. If there's a deviation as far as what the business strategy is from what your controls are, that's where you need to have a sit down with your compliance, legal, and leadership to work through those areas to get agreement as to where you want to be on the right side of those laws and regulations. So super important, again, is that executive sponsorship, that you have something set up, whether it's an operating committee or a steerco, where you can talk out these particular issues. And then once you've established what they are, get them into a policy and make sure those policies are known across your organization.
All right, thank you, Al. All right, next, you're going to see more sanctioned nation states will ramp up attacks. And yeah, I mean, take a look what's going on today even, with the potential war that might happen. If more sanctions start happening, then you're going to see more attacks probably there because their funds are getting lower. So don't be surprised if these kind of attacks start ramping up as well. Next, we have deepfakes. I don't know if anybody has seen the Tom Cruise deepfake. If you Google it, it is amazing and scary at the same time. There's a guy who has the same head structure as Tom Cruise, and he talks and looks just like him, and it's very scary what this could be, how this could be done for malicious reasons. In fact, this was taken at a voice level 2 years ago. The CEO of an energy firm believed that he was on the phone with his boss, and the chief executive of the firm was just following orders and immediately transferred $250,000, $250 million to a bank account to their Hungarian supplier. So these are the kind of things that are going to start happening more and more. And one of the questions I saw was, how do you counter deep fakes? So that goes back to having proper checks and balances sometimes. And yes, there are definitely going to be more mistakes being made here. But just like any type of wire transfer, you need to have multiple ways to verify that that transaction is legitimate. So never ever rely on an email alone for a wire transfer. I've seen multiple issues where somebody can intercept the communications between a client and the service provider, and they send an invoice with new wiring instructions, and the person, the customer, the client doesn't think to question those changes, and that's when things get really scary. So if deepfakes become more prevalent, you're going to have to be more sophisticated. Maybe after you get some message where you don't see the person directly, if you don't have that face-to-face conversation, then you have to text the person to verify that they got it, or call the person even after you speak to them because it wasn't in person. It's a little crazy, yes. I mean, deepfakes are very scary. Also, as far as privacy is concerned, there's a proliferation of IoT devices, everybody knows, and they've entered the office space as well. And the problem that we face with IoT devices is that security may not be on by default. These are devices that are just made to be as cheap as possible without the least bit of security on them. They're getting a little bit better if they're made by, reputable parties. But a lot of the knockoff companies that make these IoT devices, there's no patches even available, so there's nothing to update. And if these IoT devices get lost or stolen, so your information could be available, very dangerous. There's a law in California that says that they have to, if you make IoT devices in California, you have to follow some standards, but we're behind the curve as far as making sure these are secure. Al, do you have anything to add to this?
No, just want to make sure everybody's aware. IoT is Internet of Things, and that's any devices like your doorbell, devices that you may have, internal cameras, literally any and everything that you could have either internal to your home or your business. And it's unfortunate, but now our refrigerators, I think, know more about our eating habits than our credit card companies.
Yes, very true. I mean, some of the things that you could tackle a lot of these issues that we've talked about is through education, multi-factor authentication, single sign-on, where you're using the same credentials that you would for over and over, but those are super secure. And but if you have multi-factor on top of that, that's why it's okay to use single sign-on. But this way, you don't have a million passwords, and you don't have sticky notes everywhere, or you don't have them on Excel spreadsheets. I also recommend password managers. Those are fantastic. But the real idea is also the zero trust concept, where you're segmenting the network also. So if somebody were to hack into an environment, they would only get into one part of that environment. They wouldn't get into the whole thing. You might hear terms like microsegmentation, involved with this as well. But it's basically only giving people access to the actual systems that they need and nothing else, as opposed to many companies right now, when you plug into your corporate network, you have access to everything. And that's really what the industry is pushing, is to do away with that system, get rid of your legacy systems because they don't support this type of environment. And the last thing I want to talk about, I'm going to have Al talk about this, is, and it deals solely with privacy, is dark patterns.
Yep. Thank you, Ken. And certainly dark patterns are just different ways in which consumers potentially could be misinformed or misconstrue different intentions by an organization. A couple of examples here are deception, where you get onto a website and you see this countdown, and it says you have X amount of time before such an offer, goes away. And that countdown clock probably has absolutely nothing to do with what's going on in the background or the offer, but it's, it preys on people's fear of missing out, FOMO. Again, if it's directly related to a particular event, it makes sense, right, that there's a countdown, but otherwise it's just there to really kind of prey on that individual's attention. Other items are hidden costs. So you sign up for something and then eventually realize that the cost of whatever sign-up service you did is 3x, or the cost changes after the initial sign-up period. Additionally, we have asymmetry, and this is what I'm showing here is a good example of privacy consent, where you have an equal opportunity to say, I accept all cookies, for example, or I decline all cookies and move on. Where would be a bad example is if you get to a website and before you're even allowed to see anything, you get a big splash banner that says, accept all cookies in order to move on. And there's really no way to get around it and go see the content behind there. That would actually be in violation of the GDPR because you have to give persons the opportunity to accept or decline, or even in this case, as you see here, really explain to them what kind of cookies are being used on your website. These are tracking, codes. They're going to be going away. They're already going away in the Apple environment. Google's following suit. But it's just something to be aware of, something that you want to make sure that you're being balanced in the way you're presenting those opportunities. And finally, force continuity or ask. This is an example on the top of a UK train website where in order for you to obtain this coupon, you have to sign up for some monthly subscription. People don't really understand that. The terms are in small letters underneath, and by the time they find out, they find it super challenging to remove themselves from this monthly subscription. And on the example on the right, it's in exchange for your email address, we'd like to offer you this coupon. Well, why can't I just get the coupon without you having my email address? These are discussions for you to have with your respective marketing and communication teams and say, well, even if it's not necessarily illegal or against the regulation, is it the right thing? How do you balance, increasing your marketing reach with what's in the best interest of the consumer? And again, I'm not here to judge or to say one thing is correct or not correct, but these are the things that, again, need to be part of your discussion. You have to understand, where do you want to be seen by the consumer in an organization? There was a question that popped up a moment ago about data privacy regulations all over typically are about ensuring the CIA confidentiality integrity of PII. What should security teams do apart from their regular roles to make sure that they're investing in protecting in PII? Well, not necessarily just the security team, but the entire organization. You need to show that you're conducting diligence on your vendors. You need to make sure that any business or technical engagements are following this privacy and security by design and default. That when questions like these dark pattern items come up, that you're having discussions with your marketing teams and talking about, is this the right thing that we're doing for our consumer? Are we behaving in an ethical manner, not just necessarily, to the spirit of the law, the regulation, but are we, a company that is seen as trustworthy by the consumer? So those are things that are beyond just the technical controls that you need to think about.
Thanks, Al.
So just to kind of wrap up a little bit here on the development and the validation aspects of a program, and this is something that I'm actually in the middle of doing now again, is establishing security and privacy by design and default. What does that mean? Making sure that you have executive support, you have your charter, budget, resources, that there's alignment with stakeholders, legal, procurement, compliance, internal audit, marketing teams, the business teams. How do you get that alignment? You make sure that you understand the business strategy, that all of your regulations are kept in the context of what is it that you're trying to deliver, and ultimately that your policies and your controls are set up to support both the strategy while making sure that you're doing the right ethical thing for the customer. Then you build this program. Usually involves a lot of data mapping, classifications, understanding data flows and ownership. If you're familiar with the GDPR, you'll know a concept known as ROPA, record of processing activities. This is mapping out who, what, when, where, how is this data being used, how long is it retained, really having an end-to-end visibility over how personal data is moved and used in your organization. It's a great practice, whether it's required in the jurisdictions in which you operate. It's something that I'd recommend for anyone that has responsibilities with personal data, really useful. And then education and awareness, and again, setting up your KPIs, KRIs, et cetera, and then alignment to your jurisdictional specifics, promotion, and then promoting transparency across parties and stakeholders. And then next step is, you operationalize and you want to validate that what you've built makes sense. This is where the ISO 27001 and 27701 come into play, where you say, I built the program, now I want to see, am I able to demonstrate to an independent third party that the program meets the requirements from a security and from a privacy perspective. So something we both strongly support, Ken and I. It's important to have independent validations where possible. That's how Ken and I actually met many years ago, where he was actually validating parts of a e-commerce program for us. So he has firsthand experience definitely in this space, and I'd highly recommend, if anybody has questions, to reach out to him on this. But this is exactly what we want to do here, make sure that you're able to validate the integrity of your program. And then finally, automate. So this is just the natural evolution, as Ken mentioned earlier, where you're always looking to continuously improve. Same thing on the privacy side, you want to improve and automate your program where you can. Make sure that you have data subject access requests, the ROPA, the legitimate impact assessments, data protection impact assessments, and privacy impact assessments. All of those things you can create workflows for, have that information in the background, and it's always a good record for both internal organization, third parties, supervisory authorities ask you about it, and you can demonstrate conformance with the program with these artifacts. It puts you in a great position to show that not only are you doing what you're supposed to, but you're doing more than what's even necessary. Thanks, Ken.
All right, we're going to wrap up here with some key takeaways. An information security management system, or ISMS, is vital to addressing an organization's security and privacy risks. I highly recommend, you don't have to use ISO, but I highly recommend you use a framework because without one, you'll just have this fragmented system in place that you can never really put metrics to see that it's working and that it's effective. You also want to make sure that you test your incident response plan on an annual basis to make sure that it's relevant as threats and attacks evolve. So those incident response plans could be on ransomware, they could be on third-party attacks, they could be on various different scenarios that you make up with that are relevant. And things will change. The ransomware attacks of today are going to be different than the ransomware attacks of tomorrow. And who knows, with the blockchain and all this, the FBI really getting involved now, ransomware might decrease and there might be new threats coming up. So you have to learn to adjust and pay attention to the latest risks and threats. An adequate privacy program is contingent on how well an organization manages its security risks. Privacy regulations are nuanced, as you heard from Al talking, throughout the world. And an organization's overarching program needs to be nimble enough to address the changing landscape and, to somebody's question, and to address local needs as well. And lastly, continually assess new security and privacy risks and develop appropriate strategies to address them. So that's very important because the whole idea behind ISO is continuous improvement. And that's what you have to keep doing when you're developing whether it's your security or your privacy program, is to show improvement. And with that, I'll turn it back to Albana.
Yes, thank you. Thank you, Ken and Alfonso, for presenting today and delivering this very informative webinar. And thank you, everyone, for attending today's webinar. Just to remind you that PCB offers training and certification courses, which will show your dedication in implementing and also managing information security and privacy-related frameworks. And most importantly, you will get recognized worldwide. Also, be informed that this session is recorded and it will be posted on our website and YouTube channel, along with the slides of the presentation. Thanks to all of you.
Thank you. And if you want to reach any of us, you can find us on our LinkedIn pages if you have any further questions. Okay? Thank you, everyone.
Yes, of course. Thank you.
Thank you.
Thank you.